Thank you all for rejoining us for the final session of today's conference. We have gone through all sorts of theological and theoretical considerations of assisted suicide, both in abstract and in terms of the legislation that's currently in front of Parliament in this country. In this session, we're going to be a bit more pragmatic. And so we're going to hear from 4 speakers. That's one more than advertised on your timetable. There is a mystery special guest at the end who's going to address us as well. We are going to hear from people within the world of law and policy and the medical profession. So to kick us off, we're going to hear from Dr. Yuan, who is an assistant professor of international relations at the University of Leiden in the Netherlands. He's also a research associate at the University of British Columbia, and he'll be very well known to lots of you as a really prolific and prominent writer on these cheery questions of assisted suicide and euthanasia, both in this country and even more cheerfully in Canada. Yuan's going to speak to us this afternoon on safeguards in the Canadian system and perhaps some parallel stuff with what's going on here in Britain as well. Yuan, thank you.
He said prolific, but he didn't say high quality, so I do apologize for the sort of very boring talk I'm going to give. And also hello to everybody joining us online. I was told that YouTube had censored this live stream because it made many references to suicide, which I thought was quite fitting, really, for the conversation we're having. But as John mentioned, I wanted to talk a bit about safeguards, quote unquote, in the context of Canada. Why Canada? 5 years ago, basically every lobby group in favor of assisted suicide in this country used Canada as an example of what the UK should do. Then people discovered what was happening in Canada. And now Canada has become the example, both for opponents and for supporters of assisted suicide in England and Wales, the example of what not to do. And now it's Oregon, of course, which is the model we're supposed to emulate. Oregon doesn't keep very good statistics, which makes it easier to obfuscate. Kim Leadbeater MP, with whom we're all familiar now, Ms. Leadbeater, at the beginning of last month, gave an interview where she was asked about Canada, and she said something to the effect of, well, it's very different in Canada, because you see, Canada is a very big country, and they have trouble keeping track of their laws. England, being a small country, won't have these same sort of problems. But the argument I want to develop today is first to show you that the safeguards, such as they are, have not worked in Canada and that they are effectively worthless. And secondly, I want to make some comparisons between the safeguards as they exist in Canada and the safeguards as are proposed in the Leadbeater bill, in order to show you, I hope, that just as the safeguards in Canada are made of chocolate, so are the safeguards in the Leadbeater bill, and that there's no safe way in which to implement assisted suicide in England and Wales. And I really want to emphasize how similar Canada and the UK are, because both countries are English-speaking for the most part. Both countries have legal systems based on the common law. And both countries, crucially, have healthcare systems which are directly funded by the taxpayer, which have achieved the status of quasi-civic religion, the National Health Service in England and Medicare in Canada. And both have, of course, health and social care systems, which are under severe pressure because of Asian populations and a lack of money. And so I think the Canadian experience actually is a very good indicator of where I think things are likely to go in this country. Now, I want to start by quoting from the judgment of the Supreme Court of Canada in Carter v. Canada Attorney General, which was the case in 2015, where the prohibition on assisting suicide was declared to be unconstitutional. The judges said, I quote, "We should not lightly assume that the regulatory regime will function effectively, nor should we assume that other criminal sanctions against the taking of lives will prove impotent against abuse." So there's this great, so 9 years ago, the judges had this great deal of trust in the systems of regulation and of criminal law, which in their view were enough to make sure that there would be no abuses. How did that work out in practice? So I want to talk a bit more first about the no criminal law side. I want to talk about the regulators. Since 2018, in the province of Ontario, which is one of 10 provinces in Canada, the chief coroner has recorded at least 428 cases where medical assistance in dying was administered contrary to regulation or to criminal law. 428 cases which were recorded. In 2018, he told a private seminar that we see a pattern of not following legislation, a pattern of not following regulation. And frankly, we can't just continue to do education to those folks if they're directly repeating stuff that we have brought to their attention. So this was in 2018, the chief coroner was getting a bit annoyed at how MAID providers were not following the legal framework. Since then, if anything, things have gotten worse in Ontario. So just to give you an idea of the scale of lawbreaking which has happened in Canada, in one province, from 2018 to 2020 in Ontario, of the hundreds of cases of misconduct which were recorded, 16 MAID providers have had informal conversations with the coroner, just a chat. 51 received an educational email. They were sent an email telling them, maybe you should do better next time. 9 received a notice email, which is a sort of threatening email. Not a single one was referred to a professional regulator, and not a single one was referred to the police. So that is in one province, but that is true for the rest of the country as well. In fact, I'm not aware of a single criminal prosecution being undertaken in Canada for breaches of the legal framework around MAID, but I'm going to get to that in a minute. Just to give you an example of how do we time? Okay, wonderful. So just to give an example of what sort of cases we are seeing in terms of abuse. In one case, a doctor who was administering MAID used the wrong medication. She thought that she could just take a common medication and give a very big dose of it to kill the patient, and it didn't work. And so whilst the patient was comatose, she drove off to a pharmacy, got some emergency poison, and came back in her car and killed the patient. That took 2 hours. And needless to say, this was extremely distressing for the family and for the patient, who had to suffer what was probably an agonizing death because of the incompetence of this doctor. The chief coroner thought this was classified this as one of the most egregious breaches of law, but he did not refer the doctor in question to the police. He only made a professional misconduct complaint. The Ontario medical regulator reviewed the case, and I found her to be guilty of professional misconduct, and by way of punishment, forbade her from conducting more MAIDs in the future. That was all the consequence she had to suffer. As I said, the prosecutors are very reluctant to prosecute for a number of reasons. One, because they tend to defer to doctors. To them, this is a medical procedure, so any problems which comes with the failures in the administration of MAID should be investigated by the regulators. Moreover, there is a perception, which I think is probably true, that juries will not convict a doctor who has been criminally negligent or worse, because the culture in Canada is such that MAID has become a mainstream part of what society accepts as being normal. And in the past, when prosecutions were undertaken for doctors who were illegally killing off patients, it was very hard to get juries to convict. Juries don't want to send doctors who are viewed as good people to prison for acting in good faith, even if they lead to criminal outcomes. So prosecutors have been very weak. In fact, prosecutors have been invisible in enforcing standards and norms when it comes to punishing wrongdoing in the administration of MAID. That's so much for the prosecutors and the regulators. The other potential safeguard are the judges, and we have heard a lot, of course, in England about how one High Court judge has to approve the application for death, which is not true, by the way. It's only the High Court. It doesn't have to be a judge. It can be some office boy who has been delegated the power who can approve this. But anyway, the promoters of the Leiden bill have been talking about the judges, right? We trust judges to make decisions. Why shouldn't we trust them to make sure that there's no coercion, that the safeguards have been followed? In Canada, the judges have been involved, but not in a good way. So in 2020, the Court of Appeal of Nova Scotia held that the courts had no role in second-guessing medical judgment. This was the case of a wife challenging the made application of her husband because she thought he was not eligible. And not only did the court say in this case that the family had that the courts would not second-guess medical judgments, the court said that the wife had no legal standing to challenge the application of her husband. It's up to her husband alone and no one else. Family members have no special standing. And there's a parallel here because in the Leiden bill, there's no requirement that the family should be notified of the application for assisted suicide, and there's no standing given to the family. So as things stand now, it's not clear if a family member can actually go to court and challenge an application for assisted suicide in England. In Canada, for the most part, they are not allowed to. In another case in Canada, in Alberta, a 27-year-old woman who is autistic and who has ADHD successfully obtained permission to end her life from 2 doctors. The father challenged the decision in court because the father said she is perfectly healthy physically and she has mental illnesses, but mental illnesses do not make you eligible for MAID in Canada. And nobody so far knows why the doctors approved her for MAID. What medical condition made her eligible for MAID? Because this is covered by patient-doctor confidentiality, of course. Again, in this case, the judge felt quite queasy because the judge said, well, this woman looks perfectly healthy. I don't know why she has been approved to die. So the judge issued an injunction. But the daughter simply entered a hunger strike to starve herself to death. And the consequence was the father simply dropped his objection. So that's another example of the limits of judicial intervention, even when the judges intervene. In a third case, a woman in Alberta who suffered from the side effects of medication she was taking to treat her bipolar disorder applied for MAID. The doctors told her, no, all you need to do is to change your medication and you'll be fine again after a few months. So she called up a doctor, Dr. Rev'd, who some of you may recognize from the documentary with Liz Carr. Right? Liz Carr goes to British Columbia and talks to this doctor who clearly just cannot wait to kill her. That's Dr. Rev'd. And they Zoomed once. And she forwarded some of her medical files by email. And on this basis alone, on the basis of one Zoom, Dr. Rev'd approved her application. And she was actually, this is a small detail, but Dr. Rev'd also owns an abortion clinic where she conducts some MAID procedures. And the original plan was for her to kill this woman in her abortion clinic. In this case, again, it's the Supreme Court of British Columbia granted an injunction, and because the judge was very uneasy with what had happened. But this was attacked by the proponents of MAID in Canada as an attempt to use the courts to deprive people of their autonomy and of their medical treatment. Because, of course, MAID is now medical treatment, right? And if it's medical treatment, what business do judges have in interfering? So this case is pending, and I think this will be an important case for other jurisdictions. But the injunction is only good for 30 days, and after that, we don't really know what's going to happen. It is very possible that the MAID procedure will be allowed to go ahead. And you have to remember that in Canada, as in England under the Leiden bill, the doctor doesn't have to be certain that the patient is eligible. The doctor has to be satisfied to the best of his or her knowledge and ability that he or she thinks that the person is eligible for MAID. So if a doctor makes a mistake, there's no criminal liability attached. Indeed, the Leiden bill has a broad civil and criminal immunity provision for doctors involved in the procedure. A doctor who is involved in providing assisted suicide in England under the bill incurs no criminal liability and no civil liability, even if they botch a procedure. They cannot be sued. And this is almost unique, I think, in English law. If a doctor does not perform a procedure to a certain minimum standard, they can be sued for negligence and so on. Under this legislator bill, there is total immunity for doctors. And so that's the situation in Canada. And as I hope I have demonstrated, there are disturbing similarities between the legal regime which exists in Canada today and the legal regime which Ms. Leiden has proposed to England. And I think just as the so-called safeguards have not worked in Canada, which in many ways is a very similar country to this country, I think the so-called safeguards in the Leiden bill are frankly entirely for show. I'll leave it here. Thank you very much.
Thank you very much, Yuan, for taking us through the Canadian regulatory framework. Our next speaker is Dr. Calum Miller, who's a research fellow next door at Blackfriars here in Oxford, but is also a medical doctor working in the National Health Service. On the research side of things, he is interested in philosophical inquiries around the beginning and the end of human life, as well as broad problems in the philosophy of religion, metaphysics, and epistemology. And this afternoon, Calum's going to talk to us about what assisted suicide means for the medical profession. Calum, thank you.
Well, thank you. It's really an honor to be speaking after Yuan, who really, I think, more than anyone has been fighting this in the UK, and we're very grateful to him, who also has Twitter skills second to none, which I hope to emulate at least in part someday. Well, I want you to begin by imagining with me for a moment. I want you to imagine that one day you wake up and you can no longer move your body at all. You cannot move, you cannot speak. In fact, the only thing you can do is move your eyes around and blink. And now imagine finding out that this was not only temporary, but was for the rest of your life. Well, this is a real condition some of you may be familiar with, called locked-in syndrome, usually the result of a serious stroke. And to most people, it sounds like torture. We can barely even begin to imagine what life must be like, and we don't want to. Indeed, for some people with this condition, it really is a harrowing experience. And indeed, one of the leading advocates for euthanasia in the last couple of decades had this condition and wanted the state to allow others to help him end his life. Well, it's situations like this which help us understand the instinctive and emotional draw of euthanasia. All of us can and should sympathize with people who suffer so much in their lives, whether due to a medical condition or otherwise, that they cannot bear to keep living. The idea that we could help them to end their lives, or even end their lives ourselves at their request, seems compassionate. And indeed, advocates for euthanasia in the modern day are often operating on entirely benevolent intentions. Well, on the other hand, consider a woman called Dawn Fazey Webster. Dawn has locked-in syndrome and has done since 2003. She can only move her eyes and move her head very slightly from side to side. Well, in 2014, 11 years after getting locked-in syndrome, Dawn completed a degree in ancient history. Not only that, she also wrote an autobiography and went on to do a master's. And so my question is Dawn's life worth living? Well, of course, I'm not saying that her life is worth living simply because she has a degree. Hopefully, none of us believe that. But she seems to think her life is worth living, and she's not an outlier. Studies have consistently shown that people with locked-in syndrome generally consider their lives worth living. Some studies suggest that they even have the same quality of life as rated by themselves as the average student, which I grant is maybe not a high bar in Oxford. A recent study found that the large majority of people with this syndrome never had thoughts about ending their life, and most of the rest of them had these thoughts only occasionally. Only 13% had depression, which is a similar rate to the rest of the population, and 88% said that they were able to participate in recreational activities as they wanted to. Another recent study of 67 patients with locked-in syndrome found that at the beginning of the study in 2007, only 2 reported any kind of wish for euthanasia. By the end of the study, 6 years later, in 2013, not a single patient out of 39 reported a wish for euthanasia. The only patient who remained in the study who previously had wanted it had changed their mind. Well, I say this not to suggest that most people with these sorts of conditions are happy and therefore they should be permitted to live and helped to live, because the reality is that even if someone wasn't happy, the sanctity of life is important and must be preserved. But what I think this illustrates is that our thoughts about the quality of life of disabled people are often largely the result of our own biases. We think that other lives aren't worth living, and that people with certain conditions should have their lives ended, at least if they request it. But people with disabilities, even some of the most substantial ones, generally do not think the same way. Humans have a remarkable ability to adapt to the circumstances they find themselves in, and although yes, some people with disabilities or medical conditions do find their lives unbearable or close to it, the same is true of many other humans without those sorts of disabilities or conditions. The point is that by and large, humans are able to find meaning and purpose in their lives despite their circumstances. It's often thought that euthanasia should be available for people with intractable and extreme pain, and all of us can sympathize with that. But the empirical reality is that the overwhelming majority of people undergoing euthanasia are not doing it because of pain. Far more often they say that they lack autonomy, or they are unable to do things they enjoy, or they feel they have lost their dignity. A significant number, sometimes over half and around 40% in Oregon, say that they feel they are a burden on their family and friends. And in fact, only a small minority cite pain as a reason. A small minority likewise say that they want euthanasia for financial reasons, perhaps because alternative treatment is too expensive. We've certainly seen this in Oregon. Well, this is the reality of euthanasia in practice. And what it shows is that the things which lead people to euthanasia may be exacerbated by medical problems or disabilities, but the concerns are far more general and could apply to any of us. A lack of autonomy, a lack of dignity, feeling that we are a burden. Any of us could feel these things. But if one of our healthy friends were to say to us that they wanted to end their lives because they felt they didn't have dignity or because they were a burden, would we encourage them or help them to do it? Of course not. We would do everything we can to show them that they do have dignity because they are created in the image of God and that they are a child of His and not a burden to us. They are a gift. These are ultimately existential problems requiring existential solutions. Euthanasia, therefore, is not and cannot be the answer. And this is perhaps why the overwhelming majority of palliative care specialists in the UK, around 90%, oppose legalizing euthanasia. They realize that with good quality palliative care, almost no one ends up wanting to end their lives. And that with legalized euthanasia, the pressure on the terminally ill and others to end their lives prematurely would be catastrophic. So I want to take the rest of my time just to comment on a few medical components of this debate. The first is conscience. A starting point is, of course, the vocational core of medicine itself. The Hippocratic Oath, along with forbidding abortion, also forbids giving or even suggesting a fatal poison to anyone. The oath finds its modern equivalent in the World Medical Association's Declaration of Geneva, and this, of course, has been diluted over time, but in the immediate wake of the Nazi euthanasia regime, it declared, "I will maintain the utmost respect for human life from conception." The British Medical Association in 1947 said that specifically the greatest crime for a doctor was, quote, "the destruction of life by murder, suicide, and abortion." The prohibition on even suggesting a fatal poison is especially important in light of the superficial conscience rights which are typically granted to doctors in these situations. They're often told that they don't need to actually do the act themselves, but they do have to suggest it, discuss it, and refer onwards for someone else to do it. Well, of course, for anyone for whom these are serious conscience problems, that is far from sufficient. If I think that something is killing, then me putting someone on that pathway is just as bad, and I cannot do it in good conscience. Currently, the laws on abortion require me to violate my conscience, and if I'm ever put in that position, I will have to violate the law and follow my conscience and lose my career. That is also likely to be the case with euthanasia. Indeed, Kim Leadbeater's bill specifically requires doctors to refer onwards for such discussions. So conscience is therefore severely threatened by this bill, but that is only the tip of the iceberg. More encouragingly, though, it's notable that the importance of conscientious objection has been revived in recent times during COVID, where doctors were in terribly distressing situations deciding who should get treatment and who should not have it with limited resources. The concept of moral injury had a resurgence, and it was shown that doctors and nurses and other healthcare professionals suffer moral injury when they violate their conscience. And this has even been connected empirically to traumatic stress type symptoms, showing that there is a measurable harm that occurs to these healthcare professionals when their conscience is violated in this way. Well, secondly, palliative care. It goes without saying that assisted dying, that is, comforting someone while they are dying, and in some cases withdrawing treatment, is already entirely legal and widely practiced. Palliative care is almost always sufficient to relieve serious physical symptoms, and in extreme cases, even sedating the patient to minimize their conscious awareness is possible and legal. I'm told by one of Europe's leading palliative physicians that this is actually rarely necessary, because symptom control is usually sufficient with far less extreme means. But if it is necessary, then surely this is a preferable, even if not an ideal, alternative to killing the patient. Now, unfortunately, parliamentarians have been bombarded with misinformation and horror stories which, according to the wide consensus of palliative experts, almost always reflect failures of medical care rather than the inherent inadequacy of palliative medicine. This past week, I had several exchanges with the Reform UK Deputy Chair, Richard Tice MP, in which he asked whether someone drowning for 10 hours in their own fecal vomit was acceptable. Well, the King's College Professor of Palliative Medicine chimed in and said that this is virtually unheard of, even if it has happened in 1 or 2 cases, and in fact it's barely physiologically possible. But this has not been deterring proponents of the bill from using these stories as if they are possible, commonplace, and routine, even with adequate palliative care. Now, I say this not to smear Reform UK, since I'm a reluctant member of that party, but merely to illustrate the depth of the ignorance among parliamentarians who have been voting for and passionately supporting the bill. Therefore, the overwhelming consensus of palliative physicians on these matters must be made clear to the parliamentarians, and at the present, I believe that it is not sufficiently clear. Of course, these deaths are only likely to get worse if euthanasia is legalized. Palliative care is already underfunded, it's already stretched, and research suggests that it typically becomes even less funded when euthanasia is legalized, meaning that for all of those many people who don't want to end their lives prematurely, they face an even worse death much more frequently than they are currently having. This could actually make the very problem worse that it is trying to solve. There's a lot to say about quality of life considerations, the way that do not resuscitate forms are applied, the way that end-of-life decisions are made with young children, such as Charlie Gard, Alfie Evans. All of you will be familiar with these cases. They're highly controversial. I don't want to say too much about them, and I certainly don't want to imply that these are necessarily the same thing as euthanasia. They are often very, very distinct phenomena. But what I want to highlight is that the same attitudes that lead doctors to mistreating and discriminating against patients with disabilities, which lead them to assume that they have no objective quality of life and therefore their lives can simply be ended, through the lack of treatment. These perspectives of doctors, which are grossly ignorant, are extremely prevalent, and when euthanasia is legalized, if it is legalized, these positions that doctors hold and these attitudes that I would say the large majority of doctors hold will only take on and be endowed with a new weapon that can be used in a much more potent way against marginalized members of our society. So finally, let me say something about coercion. This is not just from family members, but we do know that about 60% of elder abuse comes from families. It can also come from doctors and from the state. We are all aware of the issues with aging societies, with the number of people with dementia roughly doubling every 20 years. One estimate suggests that 30 to 50% of your lifetime healthcare expenditures will come in the final 6 months of your life, which means that if you kill someone when they have an estimated 6 months left, the healthcare budget could be saved by perhaps 30 to 50%. And this is an overwhelming economic incentive. Never mind that these prognoses are often extremely unreliable, and you might actually save more money by depriving the patient of even more of their life. Even more sinisterly, there has been a paper published estimating the number of organs that could be made available for transplant in Belgium with their current or potential future euthanasia laws. And this practice is already underway of organ donation from euthanasia victims. Likewise, in Oregon, we know that people have been refused treatment, chemotherapy, or whatever else it might be, or even a stair lift for their home, in the case of one former Army veteran and Paralympian. She was told, Christine Gauthier, that she could simply have euthanasia instead, because it was taking too long to get a stair lift in her home. I had the privilege of speaking alongside Christine Gauthier at the March for Life in Ottawa a couple of years ago, just last year, in fact. And we had a platform that was probably about 1 foot tall. It was not a significant platform. It didn't require any huge apparatus to help someone in a wheelchair get up. It just required a small, simple ramp. The Canadian parliamentary staffers and authorities decided to decline to provide even that for the rally at the March for Life on Parliament Hill in Canada last year. Such is the contempt for opponents of euthanasia and people with disabilities from some administrative and legal authorities in Canada. Well, of course, there have been many quotes on this that sort of make this much more brazen and candid. Jacques Attali, the great 20th century statesman, said, as soon as he goes beyond 60 to 65 years of age, man lives beyond his capacity to produce, and he costs society a lot of money. Euthanasia will be one of the essential instruments of our future societies. Or consider the words of Baroness Mary Warnock, who played a hugely influential role in bioethics policy in the last century. She said, if you're demented, you're wasting people's lives and your family's lives, and you're wasting the resources of the National Health Service. If somebody absolutely desperately wants to die because they're a burden to their family or the state, then I think they too should be allowed to do it. They should be allowed to die. The reality is that for all the talk of life being invaluable, and of course it is, money still matters in medicine, and it will increasingly matter as our society ages and lifetimes extend. Whatever the intentions of the proponents of the bill at present, it is absolutely inevitable, given demographic trends, given economic trends, that economics will hijack this law and be an overwhelming incentive in favor of killing the old and the sick. I saw a GP very indignant at Diane Abbott suggesting this yesterday on Twitter, and suggesting that if she were to highlight individual doctors who might have this incentive, she would be defaming those doctors. But of course, truth is a defense to defamation, and it is manifestly true that economic incentives will play a major part in the future if this goes ahead. So there are many, many more issues with assisted suicide or euthanasia, and indeed with this specific bill. For one, we know that when assisted suicide is legalized, general suicides in the population increase. There's some evidence that suicide themes on television have a similar effect. And so suicide is contagious to a degree, and this is particularly dangerous in a Western culture that is already so ravaged by mental health problems. Much has been said already today about the slippery slope, which is perhaps one of the main arguments against euthanasia. I don't want to say too much more about that, other than that the numbers of people who currently travel abroad for euthanasia is around a few dozen, at least if I have the latest statistics. By contrast, in other jurisdictions, thousands of people undergo this. In the Netherlands, as we have already heard, there are newborn infants with spina bifida and other conditions who are murdered by their doctors under their euthanasia law. And there really is no word for it other than murder in that case. In Belgium, those receiving euthanasia have included people with anorexia, with gender dysphoria, and even a serial murderer and rapist who was effectively offered capital punishment through the back door of euthanasia. But primarily, the slippery slope is inevitable ultimately because of the logic of euthanasia. If the prevention of suffering overrides all other values, including the inherent dignity of life, then anyone who suffers intolerably should be euthanized. If autonomy overrides all other values, then anyone who desires euthanasia should receive it, no matter how transient or ameliorable their suffering is. And so ultimately, this bill and this phenomenon poses an immense threat, not only to society, not only to the old and sick, but even to the soul of medicine itself. There has been much said about this being the crossing of a Rubicon in Parliament, and I actually think that's not the case. As we saw with the Hippocratic Oath from the World Medical Association and the British Medical Association, the crossing the Rubicon occurred last century with the legalization of abortion. That's the Hippocratic perspective. What we are witnessing now is not the crossing of the Rubicon, but the fall of the Republic and the establishment of the empire itself. That makes it no less serious. Perhaps it's even more serious for that. But what we are seeing is a trend that started last century with the devaluation of human life, and this would be another gigantic step towards the establishment of a truly terrifying regime, which all of us in the medical profession and outside it have a duty to resist with every breath that we have. So thank you for doing that, and thank you for your time today.
Thank you, Calum, for that incredibly, horrifyingly informative talk. Our next speaker is Lois McClatchy-Miller, who is Senior Legal Communications Officer at ADF International, where she works with journalists and commentators and people in comms discussing these kind of fault lines of law and policy and fundamental freedoms and ethical questions. So Lois, over to you. Thank you.
My goodness, this really is like Twitter come to life with Yuan and Calum both sharing their views on euthanasia. It's much like every evening I spend on my phone, but even better because it's here with you. Well, I've been asked to share a little bit about the bill, what we have to look at going forward. Is there hope? Is what will we do in this dark situation? And it was devastating last Friday. I'm sure you were all experiencing that with me when we found the vote had not gone in favor of saving vulnerable lives in the UK. But to look forward, I think first we have to look at where we've come from and where we are now. So let me take you back to kind of at the start of this campaign, how things were looking as to our prospects of success. We had a parliament that was 79% left-wing. It didn't look like our chances were great. Polling data showed that about 60% of the United Kingdom was in favor of assisted dying legislation. Now, whether they understood what that really was is a different question, but the polling data shared in the press was that everybody wanted this to pass. The Prime Minister was in favor, and that was even more significant given that we just had a fresh general election where many young new MPs had stepped into Parliament for the first time, hadn't really thought about big, fundamental, philosophical life and death questions like this, perhaps didn't expect to face this if in their first few months of their career, and were potentially looking to their career, what Keir Starmer was saying and how they would advance going forward with this vote. There was many, as Calum mentioned, uninformed politicians and misrepresentation in the media cycle about what death was really like if people were really drowning on a frequent basis in their own feces. It's something that I've read much more than I expected to in the last few months. And finally, Dignity in Dying and the assisted suicide lobby had lots and lots of money. That's been clear with the amount of spend on Facebook advertisements and advertisements in the tube, in the subway station, campaigning for the right to die. The situation looked bleak. We went from a situation of 79% left-wing in Parliament, and we landed on a vote They looked like this: 42%. 42% of the vote was on our side. Yes, it was a big loss, 330 to 275. But don't forget that that is an incredible feat already on its own, that it came so close. I think many of us hoped that we would do just a little bit better to just squeak it. I had kind of thought that we might win or lose by 3. The best that we could have done was just to get enough to pass. We did well, but we didn't quite get enough to make it over the line. But the bill doesn't end there, although a lot of the media attention seemed to suggest it would. The bill has a further journey to go. So I want to look at what got us the momentum that took us from 0 to 42%, and see if there are lessons that we can learn as we go forward through the next few months, as the bill goes through committee stage, into the Lords, and for its third reading. What is possible? Well, I think one particular strength of the campaign has been the diversity of politicians and public figures joining together in their defense of life. This was one of my particular favorite moments of the campaign, was an op-ed written by Diane Abbott, the mother of the House and one of the most left-wing Labour politicians, and Sir Edward Lee, a Catholic conservative, always known to vote in a pro-life manner, came together in an op-ed showing that despite being from entirely different places ideologically, they could both put that aside and do what every politician is meant to be doing, every person of goodwill is to be doing, to protect vulnerable life. And I think a lot of MPs were inspired by the leadership of people like Diane and others in the Labour Party who spoke out from an early stage, including, for example, Wes Streeting, the health secretary, from a very early stage, said that he did not think that the NHS was ready for this pressure, given that palliative care services are not up to scratch yet in the United Kingdom. Nobody should ever face a situation where they have to pick between inadequate care or their death. And I think Wes recognizes it, and that's why he's been so vocal from an early stage. The Deputy Prime Minister, Angela Rayner, also spoke out against the Justice Secretary, the Education Secretary, the Disabled People's Minister, Ed Davey, leader of the Lib Dems, the former Labour Prime Minister, both mother and father of the House, 350 disability rights organisations, the Association for Palliative Medicine, the British Geriatrics Association, the Royal College of GPs, the head of the National Suicide Prevention Strategy, the CEO of British abortion provider BPAS, the former CEO, Anne Ferrady, and groups of religious, all sorts of religious groups of different faiths. The list goes on and on. The diversity of this group that spoke out into this campaign was compelling, and I think that was a huge part of winning some of those MPs who would have started off in a state of not knowing which way to turn. It made it okay, no matter what their ideological persuasion, their religion, their background, it made it okay and safe to say that they were voting against this bill. The role of religion has actually been incredibly interesting throughout this campaign. Shabnam Masood is the Justice Secretary, and when she spoke out, she was criticized because she has a Muslim faith, which she referenced in her very detailed and very well thought out argument against assisted suicide. And that caused a big conversation in the media. What is the role of religion in Parliament? Some criticized her, and others welcomed that pride in her faith. I think having different religious groups has been a great richness for the campaign. It was great to see Justin Welby speak out against assisted dying. And I know many MPs are looking to their constituencies, especially in areas of greater propensity of Muslim faith, and listening to those voices. And I think religion is actually having more of an impact, as well as the recognition that everybody has a religious influence, whether that's from a particular faith or not. If they're saying that they're influenced by atheism or secularism, that is, of course, a religion too. And I think that conversation is coming back to the floor because of this debate, which is an interesting side point. But back to the vote itself. This was the breakdown of parties voting in favor of the Leadbeater bill. So 100% of the Greens said they wanted it. We didn't manage to win one single Green. 85% of the Lib Dems, despite their leader not being supportive. Disappointingly, reform, 60% voted for, two of which were based on constituency polling. So a bit of criticism for reform has been generated for not taking the mantle of this big decision and instead going with what would be an easier option. Labour, 58% voted in favour, and I think getting 42% is a strong showing of their commitment to the vulnerable. Only 19% of Conservatives voted for the bill, and, oh no, the computer is running out of battery. Let's see if we last. Independents, 90% voted in our favour, 10% against, and the Independent Alliance voted entirely in our favour. Nobody from that alliance supported the Leidbeater bill. So you can see the shift. There's a colourful mix in there, which is encouraging as we go into the next few stages, that we aren't just targeting one side of the political market, but more. Well, what won over the other side then? What can we learn from their campaign? Well, horror stories were certainly a popular tool. Referring to that fact that public opinion is firmly in support, although they didn't exactly explain in support of what. And when we look at the details of that polling, it shows that the questions asked, when people were asked questions about assisted dying, many weren't sure if they were being asked whether they support palliative care or euthanasia, which definitely made the statistics a little bit more unclear. We're also shown, debated, this point came through strongly, was that we're not doing the Canadian model, the crazy Canadians. We're more like Oregon, much more sensible, thank you so much. We're much more like Oregon, much more sensible. However, not realizing that Oregon has greatly increased the number of people who have opted for assisted suicide since legalization too. We've been told that we have the strictest safeguards in the world. Yuan has debunked that myth a little bit for us already. We've been given confusing terminology. In fact, in Parliament, when Danny Kruger, the leader of the opposition to this bill, made his speech, he was corrected by a politician from the other side, asking him not to talk about suicide. This isn't suicide, that's offensive, she said. The confusing terminology has not fully informed the public or politicians about what we're discussing. And critically, one of the critical arguments, the most popular amongst those who were initially undecided, was if you vote yes at this reading, it doesn't mean you have to vote yes at the end. You can keep the debate going, keep the conversation going, and see if we can improve the bill. And many politicians wavering on the line therefore said, we'll vote yes at second reading and we'll see how this develops. In fact, as reported by The Independent this weekend, it was more than 30, indeed it was 36 MPs said that they voted yes, only to have more debate, and they reserved the right to vote no later. This is key for us because if you think of that differential, 275 MPs, 330, we only need to win 28 of those MPs to be able to stop this bill from going through. That's a very tough order, but it's not an impossible order, given that many have already said that they're not committed to this bill, and the debate is still very live, given the momentum that the anti-suicide, the suicide prevention side, has had. And so now, for the next few months, till probably around April, we find ourselves locked in a battle for the 28. How will this look in the coming months as we go through different stages of committee of the House of Lords? Will there be amendments? Yes. I suspect there will be a little bit of gaming and political gaming around amendments. Maybe those in support of the bill will accept some conditions. They will perhaps, oh, that's all right. We can move on past that anyway. Perhaps they will make some concessions. For example, allowing family members to know about the decision beforehand, maybe tightening up whether it's going to be a doctor or a nurse or a different medical profession involved, picking and tweaking at some of the outsider bits of the debate to see if that would satisfy, tinkering around the edges. Perhaps they'll even have some hard amendments proposed from the other side to expand this already up to 12 months or 2 years, and maybe they'll reject that to show some willingness to compromise. Now, of course, the difficulty is when it comes to matters of life and death, there's very little space to compromise. Either we're supporting assisted suicide or we're not. So amendments will be tricky to really negotiate on this one from a perspective of protecting the most vulnerable. But what tools do we have to keep momentum, to build momentum, and to win, to make sure that we have the winning arguments going forward? Well, I think there are some tools in our box that we can learn that have been already successful. I think we have to push into exposing what happens, for example, in Oregon. We've already seen incredible stories from Canada and from the Netherlands and from Belgium. The bill is often compared to sensible Oregon. We need to tap into that more and expose what's really going on there, show that this is not a perfect, ideal situation. In fact, many more people are losing their lives because of assisted suicide than were expected at the start. We have to challenge things that have become buzzwords, such as this bill will make coercion a crime. Now, of course, you and I know that when somebody is being coerced to end their life through assisted suicide, maybe by family members or maybe pressure that's being put on them, that's very unlikely to come up in an investigation. Somebody being asked, are you being coerced, is almost never going to say, no, I'm not being coerced, and that investigation will never be enough. If we can expose stories, moving stories, about how coercion has been used abroad, I think that will build momentum as well, showing that no bill can ever make sure that nobody is coerced into an untimely death. I think the other side has had a strength of having sympathetic stories, but don't forget how many sympathetic stories that we have as well to win hearts and minds. We have incredible stories, like my friend Michelle, who wrote in The Spectator the week before the bill, who made an appointment at Dignitas when she had a life-threatening injury which paralyzed her from the waist down. She made an appointment to Dignitas. She's told her family about that she was going, that she had the flights booked. But a caring and helpful and considerate GP told her that there was a better choice, booked her in for psychological therapy, and helped her make a better choice for life. And only last year she went and canoed the Zambezi River, raising thousands of pounds for charities across Africa, being able to enjoy her life in her new capacity and find that new hope. If we continue at the same intensity that we have in the last few weeks, I think we can build enough momentum to have a shot at convincing the public, at convincing politicians that all is not lost, that we can protect vulnerable lives in the United Kingdom. But asking everybody to continue at the same momentum is the trickiest part, because we all feel deeply demoralized. I know I do. I know that it's been a really incredibly difficult few weeks to look at our politicians and say, wow, we are on the brink of something terrible. But my encouragement to you is to keep fighting in any capacity that you can, to make an appointment with your MP. Don't only email them once, but make an appointment, go to their surgery and make the case. Tell your story, tell why this is important. Show stories from around the world about where this legislation has gone wrong. Use talking points that are available to show faults in the legislation, faults in the bill, which show that this is not a watertight piece of legislation. This will not end coercion, and this will not make death safe. It will simply allow the state the tools, the apparatus, to end the lives of its citizens in a very twisted and Orwellian way. I think if we continue to make that case with the same momentum and the same energy, we do have a shot, but we all need to be in it together. And that is my plea for you. Thank you so much.
Thank you, Lois, for that salutary note of optimism after an otherwise thoroughly depressing afternoon. Our final speaker I will introduce in just a second, but I have to mic him up first. So Paul, if I... Okay. Ladies and gentlemen, our final speaker is Dr. Paul Yowell, who is the Benn Fellow and tutor in law at Oriel College, an assistant professor at the Faculty of Law here at Oxford, where he works mainly on public law and legal theory in the broad sense, but particularly on comparative constitutional law. and on human rights legislation. And Paul is going to talk to us now about the Ledbetter Bill itself and take us through some sort of close reading of legal text. Paul, thank you.
Thank you, John. Yes, are we on here? Yeah. So this will be a somewhat technical talk. I want to talk you through some of the worst sections in the bill from a technical point of view. And so I think that even for people who might support assisted suicide in principle, some of the problems of the bill could persuade them against it, or there may be points for opponents to focus on amendments. So I did prepare a handout that printed all of the bill on 6 pages, but I didn't realize it would need a microscope to read. And there's another handout which I'll get to in a moment. So the first section I want to mention is section 2, which defines a terminal illness as a diagnosis of death within 6 months, which is the central requirement for qualifying for requesting for assistance. So Bishop Michael spoke eloquently of the problems with this provision this morning. And I don't really want to add to that, except to say that a study found that only 32% of such diagnoses are actually correct. So that's worse than flipping a coin. And it means that almost 70% of those so diagnosed are actually still alive 6 months later. So I think that provision needs some serious attention as the bill goes forward. Now, connected to that is that only this terminal diagnosis is required to qualify. So there is no requirement for suffering, such as you find in Canada, Belgium, or the Netherlands. In the Netherlands, it's defined as unbearable suffering, though in practice that tends to be interpreted loosely. But in this bill, the only reason that a patient needs to give is the 6 months, and then to have an intent that is clear, settled, and informed, and to show that there are no capacity issues. So I think that is a problem with the bill, even on the premises that most people use to argue for assisted suicide. Section 7 is one that lists requirements, kind of a couple of which are in the negative. And one of those is that the patient made the first declaration voluntarily and has not been coerced or pressured by any other person into making it. Now, coercion has a meaning in law that's tolerably clear from other contexts, but I don't think there's any real good analogy in other contexts for this term pressure, and there's no definition in the bill of pressure. That's deeply problematic in the bill. I think it's a major technical flaw. And it cuts 2 different ways, because in section 26 of the bill, and it's an offense to pressure someone into making it. So apart from pressure being a requirement to qualify in the first place, or the lack of pressure being a requirement to qualify in the first place, it's an offense to pressure someone into making a declaration for purposes of receiving assistance in dying. Now, something I only noticed recently, last night, reading through it again, is that it's also an offense to put pressure on somebody to cancel a declaration. Think about that. If you're trying to talk somebody out of somebody who's made a declaration, are you putting pressure on them? Do you thereby become liable for an offense? And the offense is punishable up to 14 years in prison. So I think this is just kind of a bizarre lack of clarity in the bill. The next one has to do with safeguards. I take it, I'm sorry to have missed the first part of the panel, but I take it Yuan might have spoke to that. Certainly he's been doing heroic work on Twitter and elsewhere, bringing attention to that. Tom Chaka, who's in the audience, wrote an excellent article in the Critic outlining some of the problems of this. But one thing I just wanted to highlight is that with respect to this point of pressure, there's no positive obligation to consult family, to investigate the patient's will or finances. It's open, it's possible for the doctor to do that, or the judge, but there's no positive obligation to do that. So if there were to be a robust safeguard in that sense, there should be a positive obligation on that. Section 29, coroners are more or less excluded from investigating deaths under this, which I think opens up possibilities for abuse. I can't see any good reason for coroners not to investigate deaths that come from this procedure as they do most other deaths. And then Section 25 provides exemption from civil liability for doctors assisting death. Again, I think that needs to be interrogated closely going forward, and I cannot see any good reason for such a broad exemption from civil liability to be in the bill. As Calum mentioned, there's no robust conscience protection in the bill. Section 23 of the bill does provide that no one is required to give assistance, so no one's required to participate in the act of providing the assisted suicide itself. But there is a requirement with a must attached to refer. So a doctor must refer according to this bill if the doctor is himself or herself not willing to participate in the assisted suicide or take the case forward. So there should be constant protection against the referral as well, I believe, although that's sadly lacking in the Abortion Act as well. Now, I think that the single most ill-conceived section in the whole bill is Section 28, and that is the section that I've reproduced on the other handout, hopefully legible. So I'll turn attention to that at the moment. And this is a good time to put the bill in a bit of comparative perspective. So the approach taken in this bill is distinguished from that taken in Canada, the Netherlands, and Belgium in two important respects. First of all, there's no requirement for suffering, which I mentioned earlier. That's, relatively speaking, a bad thing, I believe. But there's no permission for doctor-administered lethal injection in this bill. And I think, relatively speaking, that's a good thing. Statistics show that when the doctor himself administers the lethal injection, people are much more likely to choose it. If they have to administer it themselves, they're less likely to choose it. So in terms of reducing deaths overall, that's relatively a good thing. So in that particular sense of the bill envisioning the patient receiving medication from the doctor and then administering it themselves by the patient, it's like the Oregon approach, but there's a difference here. And in that Oregon, typically the doctor doesn't observe after giving the lethal medication. The patient goes away and does the business themselves. But in Section 18, which you can look at in particular subsection 9, we find this. The coordinating doctor must remain with the person until the person has self-administered the approved substance. And 1, the person has died, or 2, it is determined by the coordinating doctor that the procedure has failed, or B, the person has decided not to self-administer the approved substance. Now, it's very striking that there's no then, well, what next after subsection 2, after the failed. And one reason that that's so striking can be seen by the data that I have in this table right below that from 2023 report from Oregon on data summary from the Death with Dignity Act 2023. Now, first, a word about this data. It mostly comes from doctors' self-reporting. There's really no robust collection mechanism for this data. And you can see in the column, so a lot of these columns have to do with the duration of the dying process after the patient has taken the medication. So there's, for unknown duration, there's 1,200 cases. So the cases that follow that I'm going to get to in a moment are just the ones we know about. There's a huge problem of not knowing what goes on in a lot of cases in Oregon. And I think if Parliament really wants to take this seriously, they should actually send a team to Oregon to talk to doctors there, to investigate and try to find out better what's really going on. Now, I'll just call attention to a few of the figures here. So over 6 hours, there's 109 reported cases where death has taken more than 6 hours. On the range column, you have a range between the shortest and the longest, but just look at what some of the longest ones are. 19 hours, 137 hours. That's the 6-day case that you might have seen reported in the news. But then there's 20 hours, 47 hours. So in many cases, in a number of cases, it's taking days for people to die. And then there's at least 9 cases where people have regained consciousness during the process. I should add that Professor Mark Talbert and others have been drawing attention to the fact that we have no real good scientific evidence that any of these drugs cause a quick and painless death. We just don't know what happens at the kind of barely conscious level after the drugs have been administered. And there's the evidence we have doesn't allow us to assume that even in the quick cases that the death is painless. So taking these figures back to sub 9A subsection 2, it is determined by the coordinating doctor that the procedure has failed. How do we know it has failed, and what do we do next? Is it failed if it's taken 6 hours, 2 days? Certainly, I would think if somebody regains consciousness, it's failed. And then the question, what happens next, is very pressing. So there's 3 possibilities in the event of failure. It seems like obviously the most moral thing to do in the event of failure is to turn around and try to save the patient's life. But on the logic of the bill, this is just kind of bizarre. The doctor goes from assisting suicide to then trying to save the life, and obviously horrific situations could arise. Another possibility is to do nothing. It's a logical possibility. That's also pretty horrific. And then the third possibility is to complete the job. And this actually happens in the Netherlands because the Netherlands has mostly doctor-administered lethal injections, but also some voluntary cases. And then I was talking to David Albert Jones earlier, and he said that there might be 30 cases per year, I believe he said, where the doctor comes in and finishes it off. So this crosses a major line that so far has been basically excluded from the Oregon practice and excluded in what's been being sold as part of the bill, if that's the logical conclusion of what to do after the procedure fails. And just kind of see what a big deal that is, I've given you the text of the Suicide Act and the definition of murder from the Crown Prosecution Service on the other side. And right now, the bill only amends the Suicide Act 1961 to give legal permission for what's happening here. So the Suicide Act 1961 provides in Section 1 that suicide ceases to be a crime, but in the same breath, Section 2 provides for criminal liability for assisting in somebody else's suicide. So the bill, as written, provides an exception to the Suicide Act. But note that if it's going to be the job of the doctor to complete the job, it won't be enough to provide exemption from the Suicide Act alone. I think you would actually have to somehow make an exemption to the law of murder. Now that's complicated because in England and Wales, the law of murder is a common law offense. It's not statutory. And so I think you'd be envisioning something like a statutory exemption to a common law offense. And the fact that you have to amend the law of murder to allow for what the Dutch doctors do in these cases is itself quite striking. So that's more or less the list I had. There's many other problems with the bill, but I was just trying to pick some of the top ones. And I think I'll just conclude by saying this, that as Lois mentioned, there's going to be probably some strategic gaming going on at various amendment stages. It will be very interesting to see what happens at the committee level, because this is a private member's bill. Leadbeater gets to pick the members of the committee, so there's not as much robust scrutiny as you would have if this had been a government bill. I think that with regard to those who are opposed to the bill, there is an obligation to try to amend the bill in good faith to at least at some stage in the process to make it less of a killing machine than it might otherwise be. Where exactly that falls in the stage, whether it's the committee bill or Leadbeater might control everything, or whether, I think at least in the Lords there will be some opportunity to put in some good amendments. But I think that we can maintain, if we are opposed to the bill, the following position, that it's possible to try to make the bill less bad, and something like adding a provision that would require consultation with a palliative care doctor, I think could go a long way to reducing the number of deaths that are caused. But it's possible to amend the bill in very helpful ways and still at the end vote against. So I don't think these things are inconsistent. I don't think if you commit to a process of trying to make the bill better, that you're thereby committing to approve the bill in the end. And then connected to that, if you are opposed to the bill in principle, opposed to any assisted suicide legalization, then I think that at some level, it's good to either signal that opposition in principle, or at least not argue against the safeguards alone in a way that would imply that if the safeguards were fixed or if other things were fixed, then it would all be okay. And I think exactly how you make which argument in which context requires some prudence and some careful thought and some strategy. But I think I'll just leave you with that. And yeah.